Great. Welcome everyone to House Healthcare. It is Thursday, March 23rd. And this morning we're hearing some amendments on H230, which was on the floor yesterday. So we have Representative Donahue with us today. So let's start with the first one, just so everyone knows. You can find it on the House calendar, and it's on page 1096 of the House calendar. And turn it over to you, Ann.
Thank you, Representative Ann Donahue from Northfield. And yes, I have two amendments that are really a very different focus, but I'll give you the high view on the first one, and then we can look at the specifics. I think my comments on the floor were really pretty clear about my concerns, putting aside the question of constitutionality, but based on the studies, that I think there's really significant doubt about whether in Vermont, and given things like the broad availability of firearms in Vermont, that the studies really suggest that the measures the specific measures in this bill will not actually have an impact. And I actually, the last time this discussion had come up, I really urged, that was all focused in the Judiciary Committee, that we do some really just basic look at Vermont data, Vermont statistics. It's not hard to do. And then pass a statute that responds to and addresses what our real actual situations are. My hunch, I don't think we should legislate on hunches. My hunch is that it would become very clear that the waiting period would not have a significant impact other than, potentially rare, real tragedies, which we have in life in a lot of areas, but rare enough that it wouldn't justify the issue of access for others. My hunch is that the safe storage may end up in Vermont with Vermont data to show enough of a difference in enough different cases that it would be justified. That's my hunch. I don't think we should go on hunches, but we would have so much a stronger position to be in if we actually had that data saying, look, it is happening. It happens sometimes. It is happening. We should have a concern about this, but maybe we should be crafting it a little differently to actually address the specifics involved. And so this is an attempt to do exactly that. We can walk through it, and then I'll give a little bit more background. But so basically, it's asking for a 5-year look back. I think 1 year, we're a small enough state that wouldn't produce enough really good information. But a 5-year look back with the existing, primarily with the existing data that we have. And that would be at Section A, the Department of Public Safety, their judgment of who the best person would be to pursue this, but working with the Office of the Medical Examiner and local law enforcement where they have the information to submit a report back by next January, giving plenty of time to then bring forth this bill or something similar to it that's responsive to the data. So it would be a postponement of a year in terms of, because this is a substitute amendment, not something additional.
Can we just clarify that? So this would, for those that are new,
Yep.
This would basically say what we passed yesterday would go away.
Right.
And we would pass this in its place.
That's right.
Strike all amendment.
Yep. We would say we want to gather this information first and then look to what we might want to do in response. So it's, yep. Thank you. The pieces of information are very, very much focused. It's not some mega investigation, very focused on the issues and questions we're looking at. So, dividing the information that's identified, dividing it into the categories of accidental homicide or suicide, or sometimes unknown, as our data reflects. And then identifying what was the type of firearm and how it was obtained, which is really the key. There is absolutely no question about the crisis we have. There is absolutely no question that the prevalence of firearms significantly increases our suicide deaths in Vermont. Like many other rural states, it is the biggest factor in the high level because of the lethality. There's no question at all about that. But the question is, how are those firearms being obtained? That's the critical difference. That's where intervention can make a difference. So are there cases, more than a few tragic events, but is it an issue about being purchased within 72 hours before death? And secondly, where was it located? Was this accessed? And I divided it between a person's custody and control because that's what the current statute says, but also separately whether in fact it was on an individual, in an individual's residence, and whether or not it was securely stored. We know that when it comes to adolescents, secure storage is not necessarily going to be useful. They're pretty good at finding where the combination is or things like that. And as was discussed on the floor, the parent may have given the information. They're allowed to do that. If they have an adolescent who enjoys going hunting and the parent has given permission to do that, then that adolescent can have access and may at a different point of time or may have a friend who wants to use it to harm themselves. So some of those issues are important, and knowing whether or not it was securely stored and yet still able to be used would be really important in how to craft a statute that would make a key difference. And then the third part, if it was a death involving a minor, what was the relationship, family, neighbor, friend, so forth, between both the owner and the owner of the property. So I think these are kind of core in the last piece, because we're also addressing a person prohibited from possessing a firearm by state, federal, or court order, identifying that factor. So they're very specifically focused on the things that we really need to know and ought to be knowing based on Vermont data before moving ahead and identifying what the best ways to address those threats are. B1 is important in terms of making it clear this is not some mega investigation with going back and interviewing a bunch of people and so forth. It's based on existing records, which means specifically the medical examiner's report, which is there in all the cases, and then going that will identify where and when it occurred. So going and getting the local police reports, whoever did the investigation. And then if that does not, in many cases, that will provide all of the answers. But if it doesn't, then identifying someone who's already in the report, not going out into the community and starting, but somebody who's identified in those records as somebody who might have knowledge, and checking with that person. Part 2, B2, is just to assure there may be somebody who would have that information who's identified in the report, but if they're being approached by somebody to ask questions, they might feel, am I going to be charged with something? Am I going to get sued because of something I say? And this just assures that if they answer any direct answers for this purpose, would be privileged information in terms of any criminal or court action, unless if this is something recent and there's an investigation ongoing right then that would not apply. And the last piece of this amendment, Part C, is more geared to the Judiciary Committee. That is given waiting for a year. That also gives an opportunity to really see to strengthen potentially the constitutionality argument based on what does happen with one more year under our belt in terms of seeing other additional court cases. So that would have Ledge Counsel bring that back. Coincidentally, ironically, what have you, but just or anecdotally in terms of the availability of the information and the ability to really do this and bring it back and have information for us to act on. I swear it was not a setup. Tuesday evening, we had a community meeting, the future of Northfield, in Northfield. I had already submitted this amendment for drafting to Legislative Council. And this was not somebody that's involved in any of the debate or has testified in the legislature or is a legislator, but who came up to me during that meeting, was concerned about the bill and was concerned specifically around adequacy of data in terms of, are these the right and the best steps? And so he said, I'm looking into that. And I said, well, I'm actually introducing an amendment planning to do that would ask for data gathering. And he said, well, I've already got it started. And coincidentally, he was doing a 5-year look back. He already had asked for and obtained, he already has all of the medical examiner's reports. And he is beginning the process of then, because they identify location and date, to go to those towns to request the incident report records in each of those towns. So this is something even a layperson can do. Of course, he wouldn't be able to add an interview with somebody who had more information, but it was just an interesting thing that, this is a logical thing and it's not a difficult thing to really know. And particularly given that the studies that are out there really specifically identify that these kind of measures may be protective if it's a state where there is not already broad access, if it's a state that does not have robust investments in mental health efforts, if it's a large state, that's where the evidence points to these being protective. So I think we ought to be finding out the facts, not secondhand, but directly based on our own experience.
So thank you. Does anyone have questions specific to the amendment?
I do.
No committee discussion yet. We're just going to ask Ann whatever questions we want to ask. So Brian and then Alyssa.
So it's about the issue, not necessarily the details of the study, but it's about this specific piece. Because it sounds like the concern is limiting access to something that people have a right to before we have more information about it. But I guess what I'm wondering is, what do we do when a family or friends take firearms from someone, or I shouldn't say take, a person relinquishes their firearms, because usually that's what it is. People don't grab them from you. You voluntarily give them to someone to keep you safe. And then you impulsively go to a store and buy a gun. In other words, I guess even if we study it and it's not a big problem, and even if it's one person a year or two persons a year, what do we do to support that person when they're in crisis and they, if they can just go to a store and get a gun and shoot themselves minutes later?
And if the data indicates that this is an issue, if we're talking about one or two people a year, I think then we have the data to be soundly rooted in going ahead with this. But there's you talk about drowning, you talk about motor vehicle accidents, particularly with young people. There are tragedies that occur, and creating a significant statute that may or may not be constitutional, and that significantly puts significant impositions on a constitutional right, even if it is constitutional, based on a rare tragedy, I don't think is appropriate. If this data shows that it is something that happens, more than the information on rare tragedies that we have now, then I think then the foundation will be better made for moving forward. And particularly in terms of, constitutional evidence that this is the problem that needs a response. So I think in a year it will be, if that's what the data shows, it will be. But the studies suggest that won't be true. And the data that we have currently suggests, particularly in terms of the 72 hours. As I said, my hunch is that this may end up being more supportive for a safe storage approach, but not necessarily even the way it's structured here. When you think about some of the responses on the floor yesterday, if you have an adolescent in your home where you are, completely, you give the combination number to that adolescent because they use it for going hunting. That's not permitted. If their friend or they then, encounter a crisis where it's used, there may be other ways we want to approach this than the way that it's laid out in this statute. And we will have the information to make a better informed and better constructed statute than one that's based really on hypotheses that we don't have data on.
Can I ask one more question related to this? What would be the threshold at which we would consider it not a rare tragedy and a problem worth taking action to limit access to firearms?
That would be exactly what the legislature would be able to know and discuss.
Okay.
What I mean though is like, so you're saying like we would get the data and then we would decide what one life is enough or two lives enough or 3 lives or whatever it is like?
Well, in effect, yeah. I mean, yeah.
So then we as a body
it would be founded on data and it would be founded on the argument. We've found that it's extraordinarily rare. We found that it's rare, but it happens enough that we really ought to be taking this response. It's that when we have particularly a minor, an adolescent, or an unauthorized person who they accessed a firearm because it was lying unsecured in somebody's home. And it does happen. And we know now as a fact that this is happening, even if it's only a few per year, then we can justify and say, how do we need to address this? But I don't think in advance you can put a number on it. You need to have that information and then make a decision based on what those show.
Alyssa?
So first of all, I think the amendment it's information we should have been collecting all along. So
I tried to bring it.
I am fully in support of collecting this data. In fact, we actually have on Brian, I can't recall what the number of your.
And I was just looking at it, 481 or something.
Yeah,
One of the things-
481.
Whoa. We gotta, let's do this in an organized way. We're talking back and forth and everything.
H481, one of the pieces we have in there is that we want them specifically to start looking at this type of data because you're absolutely right. I mean, this information exists, but it exists in case files and boxes. It exists with the medical examiner. It exists in police reports. It is not actually collated anywhere so that we can actually use the data in any kind of digestible fashion. So absolutely, I am in agreement of this. But what we do know regarding safe storage, we already have the child fatality review team that has been in existence since 2018, and they did a look back in their first year. And I apologize, I'm not quite sure how far back they went. So we already have the data through the child fatality review team. And in it, they always indicate whether or not that firearm used in either accidental or suicide was stored safely. So we already have that data. We already know that there's children dying in our state.
Okay, so I didn't hear any discussion on the floor presenting that, and I looked at all of the documents that are on your record and didn't see that report. So that may answer that part, but I don't know that, and I don't know, what the committee did in terms of discussion or presentation. It's not in your committee files as having been submitted and reviewed. So if some of that data is available, I think that the specifics, going back to your initial point about you have a bill that's saying, look at more data, I think it's really important to really refine, it's fine to ask for more than, but really refine that we're asking for those pieces. But as far as what we know about, access by minors, I do know that in terms of accidental access by a child, that's a situation where we have had one in 10 years. So based on the Department of Health records, but that does not change the fact that the issue of deaths of adolescents is clearly there's clearly a firearm problem. If we know where those weapons came from and that they're not that they have not been secured, then I think the committee should have them on the record and review them in the context of looking at this, because I have not.
Well, we did take testimony from a member of the Child Fatality Review Team, and I quoted it with permission in my bill report yesterday. And all of these reports are posted on our legislative page under our legislative reports. So they're all there.
And I'm sorry if I missed it. I did look through all the reports and I didn't find it. So
I'm looking now too.
and I may have missed it. I'm not saying that.
There's a lot.
And,
Yeah.
I guess that being said, I do believe that there is we collect a paltry amount of data. And we're addressing that. I guess my question really is, if H230 is delayed 1 year waiting for this report back.
Yeah.
Is it? Yeah. Do you think that there is a possibility that any of the provisions in H230 might mitigate some suicides?
I think that there is a possibility that the safe storage would. I don't think we know that, but I absolutely think there's a possibility. That's why, I think I would likely end up being supportive of that if we had that data. I do want to, one thing I forgot to mention, after the last time that we had a bill, and that one was focused on a waiting period, I actually approached, this is 4 years ago, and I approached the Judiciary Committee, said I would love to jointly, to sponsor a bill gathering this data. And there was no interest in doing it. And speaking to the member I had approached yesterday, reminding him of that, he said, well, I didn't think we'd be taking up another bill. Otherwise, I might have thought it was a good idea. And I'm really sad that we didn't do that 3 years ago.
You didn't introduce a bill at all?
I didn't introduce it independently because of the Judiciary Committee was already saying it's not something we're going to look at because we're not going to be taking up another bill. There was no point in having Ledge Council draft something that the committee was already saying wouldn't be taken up. So no, I did not introduce it.
I guess my final thought is, while this is really valuable and we are addressing that, and we have, I guess my thought is I'm not willing to wait a year because I'm not willing to sacrifice who we may lose.
Well, I just want to say, I would hope that, I think we should wait for data because I think we should make decisions based on data. But I would hope that, that if the committee rejects this, that you would consider including this specifically as an amendment to this bill in terms of the very specific focus of the type of information. I have not pre-read yet, maybe behind on reading all the bills, what details are in the pending bill in terms of what will be gathered in terms of digging into more information. So I would ask the committee to consider that, including the addition of, which again is, the judiciary is going to vote, is waiting for your vote, but including the legal review over the next year to see more about whether, if there are some clear cases that say we shouldn't be putting our resources into trying to fight a battle because it has been decided on a very clear basis in the interim, that would be valuable information for the legislature to have. So,
Yes, thank you.
Okay, thank you. Art, you have a question?
Yeah, well, I just have a comment. I'm in support of this. I think it's a reasoned approach to a problem. I think that, again, reasoned. We need data first before we can solve a problem. No problems are solved usually until there's data. So for me, I will certainly support this.
Okay, so we're not doing committee conversation yet. Thank you.
it's just questions, yeah.
Just questions. So are we done with questions on the first one? And I am so sorry that I've had to step out a couple times. You know how this time of year is. So let's go to the second amendment.
So the second amendment is very specific to my discussion on the floor yesterday about the expansion of emergency risk protection orders to direct petitions by family or household members. So there are multiple points on this. First of all, there are only 15 other states in the country that allow direct petitions by family and household members. So it's not as if we're kind of behind the eight ball on this. However, most of the other states who have it do include law enforcement as an opportunity for access and help to family members who do want to move it. They still could go straight to the state's attorney's office, but this would be an additional route. So it would open it up a little bit further to help family members. I have a lot of concerns about the kind of extreme expansion of direct petitions. Family, including degree of sanguinity with no limit. Third cousin is very broad. Household member the definition is very broad. I think the Judiciary Committee, based on what the chair said, is probably going to introduce its own amendment to strike minor from its statutory authorization to file a petition. But it's extremely broad. Using the state's attorney office or using law enforcement with their expertise on filing a petition and what an affidavit should include to make the case actually maintains it as a faster and stronger way of getting assistance to put in the affidavit how to act. There was reference in the discussion downstairs to the question of, well, how would a family member even know how to contact a judge at midnight? State's attorneys and law enforcement know that route, how to get things off our hours. And the response was, well, people can be educated and they'll find out. Well, they can also be better educated about how to directly contact a state's attorney or make use of, because it's the most accessible, if they want to be able to use law enforcement. So that would be an expansion of more routes for family members. But I am very concerned about petitions being filed solely by a family member without any of that guidance or assistance, because it will be in many cases driven by emotion and not with any filtering of let's step back and look at the facts. The judge will be looking at that. The judge, by the very nature of the legal process, will kind of have to find it preponderance of the evidence, which is just the fact that it's been set forth. Regardless of any kind of ability, they won't have the ability to assess, well, are these well-founded? Are there, questions that need to be asked? The individual has no opportunity. I'm really focused on the ex parte. That's if this was about family petitioning for the regular process, I have no problem with it at all. But this is about the ex parte order, which lasts for 14 days. I mean, the other option that would have made me totally comfortable would be to say, if it's an ex parte order brought on a petition by a family member, it only lasts 72 hours before it has to go to a regular court process. But I thought that would be, less supported from the judiciary point of view because of the burden on the judiciary. This will clearly increase some burden on the judiciary because it will create the probability of petitions coming in that aren't necessarily well-founded that they have to review when they don't have the support and guidance of people who are experts in what needs to be put in an affidavit. So, and I'd add that the need for people feeling that even if they're able to get the information, they don't know how to use the state's attorney's process, they're also not going to know how in the world you would file a petition directly with the judge on a Saturday. But even the possibility that there are people who feel, I don't know how to go to a state's attorney either. It's not data-based. I don't think at this point it's a hypothetical about obstacle in either fashion. And I think we have to remember that this issue was discussed and debated and decided upon just a few years ago, that this should not be a route. And this is a brand new law. I think that waiting a couple of years and seeing if it becomes a problem, if it is an obstacle, makes a lot more sense than sort of jumping to a huge broadening in just a few years' time. So I think that's my.
Okay, thank you. Art?
Yeah, and section 4 is what section?
That's the definition of household member. So if household member is being removed, you'd remove the definition.
Okay,
Yeah.
so it's changing that. Okay.
Right. It would eliminate family or household member, and household member is defined in section 4. Family is not, but household member is. So you wouldn't need the definition if you were replacing that by adding law enforcement
Okay,
instead.
so the only piece of section 4 is the definition of household member.
Correct.
All right, thank you.
Any other questions for Ann? Great. Thank you very much. Appreciate your time.
Thank you. And I'll maybe just sit in case questions come up in the course of your discussion part.
That's great. So we are staying in contact with judiciary because we're going to kind of swap people here. So we're going to focus on the First Amendment first. We'll have a committee discussion, but Topper has to go to GovOps to introduce a bill, and he's asked that he be here for the vote. So we will not actually vote right away, but hopefully he won't be very long. So with that, on the First Amendment, which is a strike all, basically getting rid of everything in H230 and just having the report on the firearms deaths. Art.
First of all, I want to apologize to the committee. I didn't ask a question.
Oh, that's okay. It's fine.
Well,
I just wanted to make sure we didn't
like
get
an
into a
idiot.
big discussion, so that's fine.
What I said stands, and I don't have any more to say.
Yep. Melanie?
So one thing, I appreciate data always, and I think that we should use data to inform our practice, to fine tune it, and to improve it. However, I do feel that there's already a lot of data that states that securing firearms will be effective. And here's my anecdotal piece for that. If you had a child that has tried to commit suicide, the very first thing that they do when they pull you into those conferences with like all primary care providers, mental health, physicians, you name it, the very first question they ask you is, are your firearms secure? And that is their first recommendation. So if all of these professionals every time ask you to do that and require you to do that and say that this is how you're going to keep your family safe, including sharps, meds, all of the things that you can imagine, which are other things we can address, I don't understand why we would wait to have someone have to go through that process if we can have something that's like best practices to secure firearms. So that data is there, and that best practice, it has been touted by medical professionals and mental health professionals and our law enforcement, and they'll help you with it. So I would just like to put that out there.
Thank you.
Yeah.
I got a question and a comment.
Yeah.
I got a question and a comment. A question is, I don't care how the bill goes through, but if it goes through and we stop every suicide by guns, and then the data shows us that suicide raises by 30% other means, what have we accomplished? Okay, so
okay.
that's my comment. Number two, what we've done here, and I think the role of all of you, but we're not just this committee, but what I've seen in the state, we're a bunch of Band-Aid people. We try to, something comes up, we try to fix it right off. We don't really get to the root of the problems. And that's why I will vote no for this bill, because I just think that a one more year wait to get the data, I'd like to know a lot of, if a death by suicide and an autopsy shows, is it public knowledge or for the Department of
Our state agencies.
Yeah, but is it a report that drugs are in the system? Is that all knowledge that, so these studies I think are very important. I don't know about all of them, but a lot of this is very important to what we want to accomplish. And I want to accomplish all suicides.
Okay.
That's.
Thank you. So I'm going to remind everyone about testimony that we took. Thanks, Michael. We're going to do a little committee conversation. I know you had another timeline in another committee. So do you have an end time here that you need to be? Okay, great. So
we're just, want me to stay here? You want me to be part?
Nope.
Okay.
Sit down. That's fine.
Thank you.
Thank you for coming. So I also want to remind people of a couple things. One, we did talk a great deal about data, and it is one of the key requirements of the bill that's on the floor today, that the Director of Suicide Prevention amongst agencies as well as Agency of Education come forth with a statewide data-driven suicide prevention plan. So we are tackling that. I also want to remind people that we heard from Vermont Department of Health about their suicide data linkage project. And that project is going back and looking at all Vermont suicide deaths in 2020 and 2021. For me, considering 90% of our firearm deaths in the state are suicides, I think, just having the subset of suicides is most of them. And I want to remind people that they are working with data sources and partners, Green Mountain Care Board, Vermont Prescription Drug Monitoring System, Statewide Incident Reporting Network, EMS data, Department of Public Safety, Department of Children and Families, Department of Corrections, Vermont Judiciary, Department of Labor, Vermont Violent Death Reporting System, Department of Mental Health, Department of Disability, Aging and Independent Living, Areas Agency on Aging, and Institute for Community Alliances, who manage the Homeless Management Information System. So I do believe we are, just came to the one committee. I do believe we all think data is important. We put forth a bill next to do that. And that we have plans in place to ensure that the last 2 years are being looked at. But I want to go back to, I think, what Brian was alluding to. And we have data today that shows that lethal access is the how of a lot of our suicides in the state. And this bill will save lives. And for me, that's what's important. Daisy?
I think I would also remind the committee that the legislature authorizes funding every year for Centers for Health and Learning to operate the Vermont Suicide Prevention Center, which also coordinates the Suicide Prevention Coalition that's attended by around 50 different stakeholders every year that represent various public and private and people with lived experience, both lost survivors and people who have attempted suicide before. And part of those meetings, which I have attended, I don't know if other representatives attend.
I'm a member.
So you're aware of the fact that our state data analyst, Caitlin Quinn, who testified here on H230, I think a few times, her full-time job is to review data on deaths in Vermont by suicide. That data has a public-facing platform that we pay for with money authorized by the legislature every year. It's available on VDH's website. And they look at death reports. I feel like I have seen incredibly compelling data that is only limited by funding and time that people lack to lift up the tragic details that I don't know that I could handle, but they're there. And you know what? I don't want any of you to be collateral damage while we wait for more of those gory details to get lifted up. And you know what? If we do wait another year for adequate data to be presented in a format that is digestible to others, I think that if it presents anything surprising or different, we'll adapt just like we're going to do right now. And that's what I'm here to do, is to work together to adapt and get data that satisfies everybody. But I think we can also be nimble, and I think we can stop letting other people's loved ones or our own be collateral damage. I'm done with that. So I don't support this amendment.
Anyone else on this, Art?
If we used the philosophy we're using with this on everything we do, this body would never have voted to approve the recreational use of cannabis. There are so many deaths and problems associated with it. So let's not think that we don't take personal freedoms into account, okay? There's a limit to what I think the state should have people do. We are talking about the state telling us what we can do with our property in our home. And I'm fundamentally opposed to that. That alone, they're telling me what I have to do with my property and my home. And I'm telling you right now, mine aren't secure and they won't be if this law passes, period.
Anyone else on this amendment before we move on? Okay, so we're not going to vote yet because we need Topper back. So let's go to the second amendment, which is striking out family or household member each time it appears and inserting law enforcement officer. Again, kind of take us back to the testimony we heard about family members, household members, knowing what's going on with people in their home and the importance of that. Any comments?
I'm sorry.
Go ahead. You have to raise your hand. We're doing committee discussion.
I just
don't
think
talk over each other.
we heard very compelling testimony on research by Jeff Swanson. If you remember, he was the researcher from Duke. He has he's done several studies. In fact, he and his partner are the nation's lead researchers on extreme risk protection orders. And I come back to the data that they compiled on Connecticut, Illinois, and I'm sorry, then they did another state, maybe Indiana. It was an I one. But an I state. Said over 50% of when they actually, when these states fully implemented and worked very hard to have people utilize it, over 50% of their ERPO petitions came from family members. And in their data, for every 10 ERPOs, 10 to 15 or 10 to 20, they were different for different states. They had estimated that one suicide for every 10 to 20 ERPOs that were given out. And while we did not take testimony on it, we have had extreme risk protection order since 2018 in this state. I think it went into effect in July. And the utilization of our current ERPO statute it's not particularly robust. And if other states, half are being initiated by family members, then I would like to see all the hard work that was done in 2018 actually have some benefit. And I think that will do that.
Okay.
So.
Thank you, Mari, and then Art.
So I very much appreciate the process by which we as legislators can continue to work on bills in this process by bringing amendments to the committees that have worked on them. In these two instances, I strongly believe that our committee did due diligence. We did very deep and strong work, and we relied heavily on high quality evidence and data. And so I think that we can continue to disagree about how to move forward. But I stand by our process. We had a very strong process, and I stand by our ultimate position, my own position, and I do not support either amendment.
Thanks, Mari. Art?
On this particular piece, if a family member today without our bill is in a house and they see danger happening, they think that somebody could hurt themselves with a weapon, could they not call 911 today and get the process rolling?
Sure. They can call 911, and then what happens from there depends on.
So I don't see where we need to legislate. I mean, you've already got 911. Okay, you call it. If somebody's ready to shoot themselves, the process would then start. I assume they would send a police officer to the home, and it would happen. I guess I don't understand, and never had to understand why it doesn't work now. The person, okay, law enforcement's now involved. The person is talked out of whatever he wanted to do, and then it goes from there.
So I'm just gonna make a couple comments to that. I think the 911 response is different in every single community, so we can't assume what's going to happen. And extreme risk protection orders are part of the purpose is to try to get it before the point of an emergency right at that situation while someone might be trying to hurt themselves for someone else. First, Leslie, and then Alan.
I just want to comment on something that you said, Art, about the state legislating about property. We have a law that everyone in a vehicle, including backseat passengers and children, must wear seatbelts properly. Our cars are our property. So the state does take our safety and survival into account when we make laws. So this already is established, I think, as precedent. So I just wanted to make that comment.
Arlen?
Maybe I missed it. Could you just explain, if, you know, and I hadn't thought of it, Art talks about calling 911. Well, that's a quick response. Now, you go.
It may or may not be.
May or may. What about the other route? If you get a court order, how long does that take? And that's going to be the same as 911. It's going to, it may or may not be quick.
It's a very different process.
It is a very different process.
Yes. Yeah. Yes.
I don't know the exact time it takes. It does not take very long. It's an emergency.
Yeah, emergency order.
Yeah.
Within the court system, right?
It could happen in the middle of the night, I believe.
Yeah.
Is there a way to, in a timely fashion, have someone testify the answer?
So we can have the chair of judiciary come up.
Thank you.
So
All right.
let's move on to Representative Morgan's amendment, and I will let judiciary know that we need. So give me 1 second.
Sure.
Okay, sorry, welcome.
Thank you, Madam Chair.
So just to bring everyone back to where we are here. So we are only hearing your second amendment on the effective dates.
Okay, good. You answered that. So I was about to confirm that.
Yes.
You did. Thank you. All right. For the record, Madam Chair, Representative Michael Morgan from the town of Milton. I'm also serving the House Government Ops and Military Affairs Committee, as probably most of you know. And I'm here to talk about, yes, my second amendment, no pun intended. It's very simplistic. What I'm asking, my ask, if you would, in this is, as we heard on the floor yesterday, in the, what was it, 3+ hours we were there, was it? 3 hours of heartbeats, we all can't get back there, the big word that kept coming up was constitutionality. Was it constitutional? Is it not constitutional? So we also heard testimony, or from interrogations, that there were organizations within the state that are diametrically opposed on their feelings of constitutional, not constitutionality. That being the big two to me were the Defender General's office, who felt the bill was in its entirety not constitutional. The Attorney General, her opinion was that it was constitutional and felt it should pass. So it's concerning when I see that two of our top level legal entities in the state being diametrically opposed is deeply concerning to me. And what I'm asking for is to use, if the bill passes, instead of the date of July 1, 2023, we make the date be effective July 1, 2024. And the reason I ask that is that there are numerous cases pending that are putting up against the Bruin decision to determine constitutionality on various pieces of legislation or litigation that are out there in the realm of firearms and testing constitutionality. So what I'm asking for is that 1 year, as we would say in the military, strategic pause while we gather more data, because I believe in the next year we will see more of these cases come to a conclusion where there will be conclusive court cases on that will affirm or not affirm that these types of issues are constitutional or not constitutional. So it's pretty much that simplistic. I apologize. I meant to start it off as I did in judiciary. I'd like everybody to understand and be very empirically clear that I understand suicide. I have 29 or 30. I've tried to count them up in my nugget this morning between both sides of my family, first cousins. Unequivocally, one of my top 3 favorite cousins 7 years ago ended his own life. And I was probably one of the most instrumental people in his life trying to get him to not do that. So it's an emotional thing for me too. I get suicide. I understand. I have firsthand experience with it as well. But I also feel that we have a role to protect our Constitution. And that's where I'm coming from when I vote and work within all of this. That's my, just want to give you all that kind of that. I meant to set that landscape a little bit for you before we did this. that particular cousin that ended his life was like a brother to me. And we were that close. So anyway, I just put that out there as, I'm not using it as an emotional prop, if you would. It's just, I get it. And, but that said, I want us to follow the law.
So thank you, and we're sorry for your loss.
But thank you.
And it is so interesting through this entire process, the last many weeks, how many people in this building are affected by suicide.
Sure.
So
I think we all have some nexus somewhere to it. It's it in the military as a senior leader, I dealt with a lot of it. I shouldn't say a lot of it. My share of it. So in talking with our chaplains, those are the folks that are kind of we have, call them DPHs, directors of psychological health, that we work with people. Some instances people sought help, some they didn't. And it was interesting just to hear some of the data, their data points, if you would, of what drove people to those conclusions in their lives. And I would have to say this, I would just throw out there, and it's not to water down this bill by any means, but is just that in talking with one of our chaplains, his words to me were, is that individual is hell-bent on doing it no matter what means. And I'm just repeating his words. Those are not my words.
And we have heard testimony that absolutely contradicts that. So thank you, though.
So that's all I have. Unless you folks have questions for me, I'd be happy to answer.
It is Brian, at least.
You have a question. I understand your intent. I don't know if I can say that. I think I understand what you're doing, but a question I have about the approach is, so if the current legislation passes with the effective date.
Yes.
And it goes into effect, and then there's a court decision that rules that kind of action unconstitutional. I'm going to ask a few questions and let you.
Yeah, sure. Go ahead. I'm following you. Yeah, sure.
My understanding is then, if it's federal level, I guess this is a question that maybe Ledge Council would answer too, is would someone have to challenge our law specifically in court, or would it get overturned if something happened on the federal level? And then if we delayed it a year and that court action happened, wouldn't we have to then repeal it or do something anyway, even though, you see what I'm saying? It's like changing the date. Mm-hmm. The only thing I see that doing is allowing people to continue to be able to go to the store and get a gun when they're suicidal and shoot themselves within minutes while we're waiting for the courts to decide. And I guess I would want to err on the side of having people not do that for a year and then having to change the law, then making a decision. And so I guess the question is sort of what, I don't know if I have a specific question. It's more like I'm trying to understand the strategy or the benefits versus cost, maybe is a good way to put it.
Sure.
Of having it go into effect now. Mm-hmm. Or waiting for it to go into effect because of court decisions?
So I think on that, Representative Chena, I think the answer is I agree with you. It's just philosophically on how we get there. You're saying, I'm just saying it from the opposite direction, if that makes sense.
But you don't want to deny people's rights for a year if they might get, and yeah.
And it's to simplify it or down to the most guttural level. Yes, correct. Yeah.
Any other questions for Rep. Morgan? Right. Thank you very much.
Thank you. Appreciate your time.
Voting yet because we're waiting for.
Understood. Yeah, you're understanding properly. You're waiting for him to show up. So you need me to hang out or?
No, I think we're good. Thank you.
Okay. Thank you for your time, folks. Appreciate it. Good to see you, colleagues, as always.
Nice to have you upstairs.
Okay.
Thanks,
I've never been
Michael.
up here, so it was like climbing Mount Everest. The air is different up here. Spinners.
You get your exercise.
I only did 20 minutes on the Peloton because I was time constrained this morning, so it gave me a little bit more on my steps.
Yeah, nothing
There you go. All right, y'all have a good day.
Thanks, sir. All right, so we're just going to hang. We're still live for a minute. Martin, Chair of Judiciary, will come up and try and answer some of our questions on the extreme risk action order.